I don't have to. Hi, everybody, and thank you for joining our meeting this evening, hosted by the Lyme Association of Greater Kansas City and Minnesota Lyme Association. I'm Judy Campbell, for those of you who don't know me, the president here in Kansas City Group. And for those that are new to our meetings this year, the Kansas City Group has combined efforts with the Minnesota Group once a month to present special guest speakers. We will always meet those speakers on the third Tuesday of each month, excluding April of this year. We have a special guest speaker on the second Tuesday in April. All the speakers are somehow engaged with us to help with the Lyme communities. And I thank Britt and Ann Muir from Minnesota for all your efforts in working with me to make this happen. We look forward to a great year ahead, and each month is filled with speakers to help us along the journey. Tonight, I want to introduce to you Matt Grunday. He's the attorney at law for disability in the Missouri-Kansas area. Matt focuses his practice on the representation of disabled persons seeking Social Security disability benefits in the Kansas City, Missouri area by assisting those who are unable to work and function in their daily lives. Matt can achieve his goal of helping others seek compensation through Social Security law. As a seventh-generation Clay County, Missouri resident and fourth-generation attorney, Matt has a deep respect for the Midwestern work ethic of those he represents. He earned his Juris Doctorate from the University of Missouri, Kansas City School of Law in May of 2001. Matt's also a member of the Missouri and Kansas Bar Associations, the Organization of Social Security Claimants Representatives, and the Clay County, Missouri, and Kansas City Metropolitan Bar Associations. As a Social Security lawyer, he is admitted and licensed to practice in both the United States District Court for the Western District of Missouri and the District of Kansas. Please note that while Matt cannot represent those in Minnesota, he can give you valuable information and you can take notes as you contemplate filing or know someone who needs to file for disability, or if you just have some general questions. So we are going to go ahead and get started. And Matt, we thank you for talking to us this evening. And anything else you want to add to that, please feel free.
No, that was plenty. I was like, you could have just said, hey, it's Matt. He's going to talk about Social Security, but I appreciate it. It was nice.
Can I just add one thing before we start?
Sure.
If everyone could please mute themselves so we don't get a lot of background noise, that would help, especially with the recording. And we'll have time hopefully for questions at the end where you can take yourselves off mute, but for the bulk of it, if you could stay that way, that'd be great. Thanks.
Thank
Absolutely.
you. I forgot that.
Sure. And if you have questions, I've got the chat open. So if you have a question that's kind of about what we're talking about at the moment, feel free to put it in there because that's what you guys want to know. And I mean, I've already seen this presentation, so I know what's going to happen next. But if you have any questions, just feel free to put that in there. I want to start with something that's not actually on the PowerPoint here, because people always worry about how they're going to pay an attorney for representation. This is not like divorce or a speeding ticket or bankruptcy or anything like that. So you shouldn't have to walk through the door with a retainer fee. Social Security attorneys get paid based on federal statute. It's 25% of the back due benefit up to the statutory maximum at the time. But you don't have to come in with money, because a lot of times, my clients can't work, so they don't have money to pay out. So that's based on the benefits that they receive for their back due benefits. I will say I do limit my practice to Social Security disability because people ask about, I had somebody earlier asking about his pension through his union. I'm like, I have no idea. They're all unique, so I'm sticking with Social Security. And we'll talk about kind of that process, what Social Security looks for. But start with Social Security has two main programs for adults. They have Social Security Disability Insurance, or SSDI, or DIB, or Title II. They're all the same thing. which is a merit-based benefit based on your work, how much you paid into the system. I'm sure folks here are old enough to remember when Social Security used to actually mail your statement to you, and your whole life's work would be broken down in this little green box of green ink. They don't send those out anymore. You have to get a MySSA account. But when you pay your FICA taxes, you're paying into Social Security disability insurance. And if you think about it like, the I is for insurance. The FICA taxes are basically your premium, your insurance premium for that benefit. Unlike American Family or State Farm or Shelter Insurance, they have a formula. Social Security has a formula for how long that coverage lasts. And we'll talk some more about that. But so if you stop paying in today, it doesn't mean that your insurance lapses tomorrow. But the other benefit, if you have not paid into Social Security disability insurance enough, the other benefit that is available is supplemental security income. It is a need-based benefit. It has asset and income restrictions. They're very low. I don't make the rules, but I'll tell you what they are. So it's possible, because of the way those systems work, to be completely disabled but not technically qualify for either benefit. But the first thing Social Security looks at when they assess a claim is whether or not someone is currently working. It is possible to be currently working, but not, but also still be able to apply for disability. And I apologize because this figure here is the 2024 figure. For 2026 or for 2025, it is $1,620. So the first thing Social Security does when you apply for disability is they ask whether or not you're working. If you are working and making over 1620 as opposed to 1550, if you're making over 1620, you do not qualify for disability. It doesn't matter that you used to make $30,000 a month and now it's only 1620. Social Security has a line in the sand, and that's the line. So if you make 1620, Social Security says that's enough to live on, and you're not qualified. You won't be technically qualified for a disability benefit. Now, I will have people call me and they'll tell me the rule, and they've been making, well, in 2024, they would have been making, well, I've just been making $1,500 a month every month. I will tell you, every figure in Social Security is pretty well stagnant, fixed, except for that one. Because, and we'll use this number just as the example because it's the one on the screen. I told you it's 1620 for 2025, but if someone works and makes $1,500 a month, month in, month out, without any variation or much difficulty, the likelihood of Social Security granting a claim is pretty slim. Because what that appears to Social Security as is that you just know the rule and you've kept your earnings under that amount. And they have two names for it. They call it self-limiting. So it would imply that because you can do it consistently, you could probably do $50 more. Self-limiting or parking your income. So typically, I will never tell anybody they can't work. I won't tell anybody they can't work over SGA, but I'll just tell them what the repercussions of it are. And so SGA is, I apologize if I'm using the acronym, it's substantial gainful activity. It's that defined term of 15 or 1620 a month. But if someone can make close to that, Social Security's assessment then is whether or not they can make an extra $50. And if you're making $10 an hour, that's, like an hour and 20 minutes a week. It's going to be 30 minutes a day. I don't know how many minutes a day. I'm not doing the math. But typically when someone is going to be working and applying for disability at the same time, because just because you're not able to sustain full-time work doesn't mean your bills stop. I generally recommend that they don't make more than about $1,100 to $1,200 a month gross, so that when Social Security starts looking at it over an annual period, you're not that close to the limit. Does that make sense for everybody? I hope. I'm seeing some yeses. Because like I said, I've had people call and say that they're making $1,500 a month and they're right under the limit. And I'm like, that's too close. The other thing I will say is that limit applies after you qualify for disability as well. But Social Security has another figure based on what they call a trial work period, where if you go over that, it can trigger a review of your benefits. So after entitlement, if you make more than $1,100 a month and you do that for a prolonged period of time, it can trigger a review of your benefits, which you also don't want. So I typically recommend, and that's the gross figure. So that's before they either one, whether or not it's the SGA 1620, that's the gross figure. So the biggest number on the check before they take out taxes, before they take out child support, but before they take out a garnishment, before they take out insurance, the biggest number on the monthly check. So once Social Security has looked to determine whether or not someone is working, if they're working under substantial gainful activity, they'll move on to the second step and determine whether or not someone technically qualifies for that benefit. If they're over, you will just get what is called a technical denial, and they'll say you're making too much money, therefore you don't qualify for the benefit. And it does no good to appeal that. You can appeal it all the way to the judge, and the only thing that the judge will look at is whether or not you were making more than $1,620 a month when they denied the claim. He won't look at medical. It's not a medical decision. It is a technical decision. And I've seen people wait around for a year which was pointless because there's no real application pending. It's just whether or not they were working at the time over SGA at the time they were denied. But once they've assessed that someone is not working SGA, they'll move on to the next step. They'll first check to see if someone has enough quarters for coverage. So we talked about earlier, I talked about the fact that the SSDI benefit, requires you to pay your FICA taxes. Then they work on what's called quarters. The general rule for anybody over 30 is that you have to have 40 total quarters. You can earn 4 quarters in a year. So that's 10 years of work. If you are under 30, they have a formula based on your age as to how many quarters you have to have. It's a minimum of 6. So they'll look at whether or not you have quarters. Quarters, as I said, are based on paying your FICA taxes. So for 2007 was my favorite year because the math was easy. Once you paid FICA taxes on $4,000, you'd have all the quarters you could possibly get. So for 2025, a quarter is $1,810. So for 2025, once you've paid taxes on $7,240, you have paid in for all 4 quarters. And it doesn't matter if you earn that on January 1 or you spread it out evenly over the year. Okay. So that's the kind of the bare minimum for that coverage for a disability insurance benefit. When you pay more, when you pay in on more than the $7,240 a month, your monthly benefit goes up. Okay. It's kind of like any other insurance policy, like a life insurance policy. You know, if you have a Gerber life insurance policy that your grandma pays $5 a year for, you get $5,000. If you pay, $300 a month, you can get $1 million. It goes up based on paying increased FICA taxes. Now, where this gets a little fuzzy, because I told you that Social Security does not have, you don't get cut off like right after you stop working. Like if I hadn't paid my American Family bill and wrecked my truck on the way here and called them and said, hey, I totaled my truck. And they said, well, we're really sorry to hear that, Matt, but you didn't pay the premiums. So you're not covered. Social Security has a formula where they look at that, and I'll back up here because it says you have to have 20 out of the last 40 quarters, which is 5 out of the last 10 years. So if you've paid your full taxes for the year, just assume that at this point you've already paid on $7,240. That covers you through the end of 25 and then for 5 additional years. Okay, assuming I've paid my taxes up to this point. It gets really complicated when you have somebody who has a spotty work history where they've made, $10,000 or $100,000 one year and then $4,000 the next, because you don't get more quarters in the year you made $100,000. You can still only get 4, but then if you only paid in on $10,000, or I'm sorry, $7,000 the next, like for 2025, that's only 3 quarters, even though you paid in on 100 the year before. They're only earned in the year that they're paid. So it can get complicated, and I actually have to like write it out. The easiest way to get it creates what's called a date last insured, which is the date by which you have to prove you became disabled. So someone earlier was talking about the fact that they were, really hoping they could go back to work and not really wanting to apply for disability. And that's good because, like I said, it is a hard decision to apply for disability when you feel like you're giving up. I always tell folks, when I call folks, I ask them how they're doing, and usually they'll say they're okay. I'm like, well, nobody ever calls me on their best day, because if they were having great days, they wouldn't call me. But in this process, you're going to end up paying your FICA taxes. It creates a date last insured, and that is the date by which you have to prove you became disabled. Once you stop paying your FICA taxes, every 3 months, a quarter drops off, and you are 1 quarter closer to being uninsured. If you are uninsured for a disability insurance benefit and you have too many assets or resources to qualify for an SSI benefit, you can be completely disabled but not qualify for a benefit. The best example I have of that is actually a friend from law school, who she was one of 5 kids. She was number 3. Mom stayed home after her, and her date last insured ended up being, it was end of June of 1974. Her mom was hit by a drunk driver 4th of July weekend, 1974, and paralyzed from the waist down. So clearly disabled, but she had stopped work 5 years before that. And her date last insured was the end of June, because it's the end of March, June, September, and December. So the end of those quarters. So she didn't qualify for a disability insurance benefit because she hadn't worked recently enough, and she did not qualify for an SSI benefit because her husband had made too much money. So as I said before, it is not a fair system necessarily, but they draw those lines. It is based on when taxes are paid, and if you don't pay into the system, eventually you can't qualify for the disability benefit. Now, upon reaching her retirement age, she could still qualify for a retirement benefit, and she had paid in enough to qualify for Medicare, but she couldn't get Social Security disability benefit because she hadn't paid in enough recently. Yes, with your hand up, Britt, you're on mute.
So for her, it was only a timing issue. Like she would have gotten it had the timing been on.
Yes.
Okay.
And really, I mean, another real life example, 2 blocks south of me is a buddy who's a practicing attorney, and his wife stopped work after child number 3, because eventually it's just more expensive to keep them in daycare than it is to, you're like, I'm losing money by going to work. She stopped working, and after child number 3, and within 90 days of that date, she was diagnosed with MS. And it wasn't disabling at the time. It comes on, and maybe it won't be disabling for a decade. You don't know. But I told him that he was blessed with being self-employed, so he should make sure he knows how much it costs to FICA to get quarters, and he should pay his wife every year enough to get 4 quarters, or at least 2. 2 keeps you currently insured. 4 keeps you insured 5 years out into the future. So that when eventually it became disabling, she would qualify because, well, that was probably 15 years ago that happened. She's still not really disabled by MS, but it's more of like a when than an if a lot of times. So yeah, the timing of it, once if your date last insured is December 31st of 2024 and you get in a wreck on January 1, you don't qualify for a benefit because you're out of time. If you do not qualify for a disability insurance benefit, they will look to see whether or not you qualify for SSI. And it's possible to qualify for both. You get paid the larger of the two. They don't stack on top of each other. The SSDI benefit is based, like I said, if you pay in a little bit, you get a little bit out. If you pay in pay in more, you get more out. So it's possible to have a low disability insurance benefit that's lower than SSI, the need-based benefit. For 2025, the SSI is $967. And I've had clients qualify for the merit-based benefit. I had a fellow who was a construction worker and had paid in, but he had too many cars, because I'll hit this in a second, but you can have one car of any value, one house of any value, as long as you live in it, and still qualify for the need-based benefit. But if you have multiple vehicles, which he did, and the total value of that was over $2,000, he qualified for about $495 worth of disability insurance benefit, but didn't qualify for the need-based benefit because he had too many assets. And you just, like I said, you just get the larger of the two you qualify for. So the SSI need-based benefit is, and I don't know what Minnesota restrictions are for Medicaid, but it's similar in the state of Missouri. So in Kansas, for Social Security, they're looking at a couple things. The first thing they look at, which is easiest, is whether or not you have assets excluding or that exceed $2,000 for a single person or $3,000 for a married couple. And that is the non-disabled spouse's 401k, Roth IRA, any sort of savings you have, all of those sort of things can disqualify you from an SSI benefit. And then they start looking at whether or not you have any other source of income. A spouse's income counts. Just as it says, it's a complex formula to calculate the eligibility, but as a non-disabled spouse starts to make about $24,000, the SSI kind of tapers off to nothing. If you have kids, it opens up again. So if you have children, it increases that amount. The $2,000 and $3,000 is what it is, no matter how many kids you have. But they also look at the person applying, and it also counts as a resource if it's the non-disabled spouse. But if you're applying for disability and you're getting unemployment, that's a dollar for dollar offset against the $967 you can get from SSI. Same thing with work comp during a period of workers' compensation, at least in Missouri. I don't know about Minnesota. There's a period of time where you can get weekly checks for temporary total disability. Those are 100% offset. VA benefits are 100% offset against the SSI benefit, and child support counts as 2/3. Because I had a gal call for me to represent her, and by the time we did the math, after her child support was offset against her SSI, she would qualify for $7 worth of benefits, and she decided it wasn't worth it. And I mean, like, you're welcome to do it, but I told you earlier, like, our fee is 25% of back due benefits, and it'd be pretty tough to work for 25% of $7. to represent her, even if it's a month, to represent her to get those benefits. So those are the two like main areas where they look at the eligibility or the resources, and then assets. And then, as I said, when they look at things that you can have one house of any value as long as you live in it. I had a gal call me. She hadn't worked in a number of years. The only asset she had was her house, and she had to rent it out to make bills, like just general living bills, but lived with her sister. So she didn't qualify for an SSI benefit because she had a home that she didn't live in. The idea SSI is a our money benefit. It's a collective, like our money. SSDI is your money that you pay in. SSI is an our money benefit, and Social Security pretty well expects you to be out of your money before you can get to our money. They're expecting you to spend your money down before they start paying. But they won't look at one house of any value, one car of any value. The second car starts applying to the $2,000 or $3,000 asset limit. They do not look at household goods, and they will not come to your house and look. Because I had a guy, after I won the claim, tell Social Security he had a $5,000 sword collection, and just he didn't qualify for SSI until he sold the sword collection and spent the money. Now, I question whether or not it was really $5,000 worth of swords. Like, he may have paid that much. You may love your mini pearl Franklin Mint plate and have paid a ton for it, but that doesn't mean it's worth what you paid. But they're not going to look. I had another one who had a Matchbox car collection that he was so proud of, he decided to talk about. Like, they're not going to look in your house. But those things don't count. Life insurance policy with a face value of $1,500 or less, or burial assets not to exceed $1,500. I will say, when you deal with, I think it was Steve, I can't remember, I apologize, who was talking about his son having Lyme's. Sometimes you have to worry about like a well-wishing grandparent that gives them a savings bond. I want an epilepsy case for a kid whose grandfather gave him a $3,000 savings bond that was in his name, and he didn't qualify for $900 worth of benefits for like a year and a half until they got it all straightened out and got the money out of there. So he gave up like $13,000, $14,000 worth of benefits because of a $3,000 savings bond that his grandparent gave him. So sometimes you can be thinking it's a nice thing to do, but it can interfere with other benefits. Once Social Security, and this is kind of, this slide is in here because I don't know where the heck to put it. And I will tell you that these numbers change all the time. I had a buddy describe this process as the pig in the python, because it just gets stuck someplace all the time. It used to be that initial applications were considered in 3 to 6 months, and the letter that you would get from Social Security would tell you you'd get a response within 90 to 120 days. Now it says it's probably closer to 10. It's easily 12 months on an initial application. Probably the same for reconsideration. Requests for hearings used to be a year. They're probably 5 to 6 months now. I just did hearings in February where we requested the hearings in August. So that's gotten smaller. The initial and reconsideration has gotten bigger. Social Security had put on hold so once you're on benefits, that doesn't mean you stay on forever. If you're 59 years old, they're probably not going to review you, because the closer you get to age 62, the less likely they are to even look. But if you're 25, you're going to get reviewed, almost guaranteed. But Social Security just they put a hold on 200,000 reviews, and they took that hold off. So, and those reviews go to the same people that do initial applications and reconsiderations. So the pig in the python just got way bigger at this level. I do not know what it's going to do. Hello? Nope. I don't know what it's going to do, but I suspect it'll create a longer wait at that level. Like I said, the request for the hearings, by the time, once you get denied, it's typically 5 or 6 months, 7 months between the request for hearing and the actual hearing. Appeals counsel in federal court can run the gamut. It can be 60 days. It can be a year and a half. I don't know that there's any logic as to how they peel those off their stacks of appeals. But it is not a quick process once you get up there. We just won a case 3 weeks ago that we had taken up to federal court and back down, and we took that case in 2020. So it took 5 years. But we won. We just kept hammering away at them. So the definition, once Social Security starts looking, you qualify technically for either one of those benefits, SSI or SSDI, merit-based or need-based. Social Security starts looking at whether or not you qualify medically. It is the exact same standard for Social Security for disability, SSDI or SSI. Because I'll have people call and find out if they can get SSI while they're waiting to get their SSDI, and the answer is no, because it is the exact same standard. It's the inability to engage in substantial gainful activity, which is the earnings we talked about before of $1,620 by reason of any medically determinable impairment, physical or mental, which has lasted or is expected to last for not less than 12 months or expected to result in death. And that means like imminent, not someday your diabetes will kill you if you don't take care of it. I mean, it has to be to the level of, it's a fairly impending death. So it is and medically determinable there means proven by the records. That is the big area that you can work on in a Social Security claim. I always have set aside an hour when we take in a client and we talk about Social Security's process. We talk about how it is that Social Security is going to look at this, but they're going to look at medical records. If you have a problem and you don't talk about it, if it's not in the records, then as far as Social Security knows, it didn't happen. If you and your wife are the only ones that know that you're in that much pain, and you don't tell the doctor, and you go to the doctor and you say you're fine, the records say you're fine, Social Security reads you're fine, as far as they know you're fine. I had a case, this has probably been 5 years ago, kid out of Lee Summit, Missouri here, who was very schizophrenic, saw things, heard things, had lots of problems. And he applied on his own, got denied. We took it to take to a hearing, and I got all the records. And all the records, every time he would he went to the doctor once a month, which I always asked him to, more treatment is better as long as it's good. But every time he went to the doctor, he said he didn't hear things, he didn't see things, he was fine. Write me my scripts, I'll see you next month. And we got ready we had a pre-hearing conference where we talked about it. And I'm like, all right, we talked 4 or 5 months ago and you said that you were hearing things and seeing things every day, but your records say you're okay. And he said, well, it was like they hospitalized me and I'm never going back. So I don't tell them anything. I just tell them I'm fine. I'm like, well, I've never been psychiatrically hospitalized. I don't want to be. I don't want to find out. It doesn't look fun in the movies, so let's not try it. But you got to understand, when you go see a doctor or when you go see a judge, all your medical records say you don't hear things or see things. So when you go in and say that you do, one of two things is true there. You're lying, or you've been lying to your doctor, and you're not adequately treated. Because that's the other thing Social Security looks at, is if you're compliant with your doctor's suggestions. If they say, try this, and you're like, nah, I don't think I will. Social Security is really not very forgiving. They want to pay people who are doing what they're supposed to be doing, but still not able to work. So the definition there is the same. for both programs, regardless. Does anybody have any questions on that? No. It's clear as mud.
Matt, this is Steve.
Yes.
If I'm understanding you right, what you were just saying is, number one, you've got to have medical records. So in
Yeah.
our case,
Lots.
if my son has Lyme and has been tested and supposedly has Lyme and has the symptoms, and of course we've been doing this for, a decade or more, and but we kind of do the treatment with herbs. And although we go to a doctor once in a while, we don't have much of a
Make it
trail
hard.
there.
That's going to be pretty hard.
Okay.
I will tell you, nobody gets paid because their dad says they should. That's part of the problem you're going to run into.
Yeah.
It's,
And let me just ask you one other question. When you were talking about quarters, he's never been able to work. And you talked about maybe paying your spouse or whatever so they'd have some quarters. Do I need to consider that? Would that work if I
without the medical treatment, it probably doesn't matter. I mean, you still have to prove disability.
Okay.
So it's, and I appreciate that you're treating it in a what would be a non-medical way, really. But Social Security is looking at records. And here's the thing. So Lyme disease is like a lot of things. You can have it and be able to work. You can have it and not be able to work. So the diagnosis itself doesn't really mean anything other than you have potentially that constellation of symptoms, right? Because there are people, there are people with schizophrenia at work right now. There are people with schizophrenia who can't work right now. Same thing. So everything is a degree of severity. Because they always call, I think autism is a good example because they call it a spectrum disorder. I'm like, everything's a spectrum disorder. Like you have a little bit, you have a lot. You're like, where are you on the spectrum of symptoms? So, and that proof comes from going to the doctor and talking about the problems, so that they're well documented. And if you're missing your legs, it doesn't take a whole lot of treatment to show, like that's a yes or no kind of thing. They're like, I can't get around, and your prosthetics don't work. There's Social Security is picky about a lot of things. There are some things that can be proven just with like 1 or 2 appointments. There are, but those are going to be catastrophic and very obvious. Typically, there's some diagnoses that just by their very nature will get you disability, but they are rare. They're called Terry cases, or Blue Book cases. But that, ALS is one of them. Once you're diagnosed with ALS, everybody pretty well recognizes that that's going to be not a very fun thing to have, and it's going to be bad pretty quick. But like I said, MS is one of those things that you can have for decades before it gets to the point where you can't work. So it's the documentation of the impairments. If you have the diagnosis, but there's no documentation of the severity of the impairment, then that's where you go back to the medically determinable impairments that's going to prevent you from earning SGA. And they set that bar really low. 1620 is not a whole lot of money to go out and earn every month. So
yeah.
Yes, ma'am.
So what if in cases when people are either self-treating themselves with herbs and supplements or seeing like a chiropractor or something, what if this wasn't my case, but like, what if they then went to their doctor, so it was reported and they said like, your medicine didn't help me, but this is what I'm doing? Wouldn't the doctor still put it in the visit notes? So wouldn't it still be documented? Wouldn't that still help as far as building an SSDI case? Like, hey, I'm taking these and they're helping me. And when you had me on that.
Well, if it says if it says it's helping, then probably not. I mean, that's the hard part. If you can say that it was refractory to all other treatment. I mean, but you kind of have to document that you've exhausted the other methods and nothing's working. But you don't.
I'm just wondering if like
you don't want to say that the herbs are helping, because then Social Security says, well, you said the herbs fixed it. You're like,
Well,
Excuse me.
again, it's a spectrum, so helping, so you're not
I
crying
get it.
in pain all day, but can you work? That's two different things. But again, I understand what you're saying.
I get
Okay,
it. Yeah,
okay.
no, this is definitely when I talk to folks, I always say talk about the worst 3 days you have in a month. I'm not suggesting you can't have a good day, but I don't want to hear about it. I don't want to see it in a record. I'm not saying you can't. I mean, what is it up there? So down here we have the Ozarks. Up there you have, that's not Minnesota.
10,000 lakes.
10,000 I'm thinking of the other one. I can't remember what it is. It's basically just like a place with a bunch of go-karts. What is it?
The Mall
I
of
don't know.
America? I don't know.
No, that may not be in Minnesota, but I'm not suggesting somebody can't have a weekend away, but don't tell your doctor you're going on vacation. Because the person at Social Security that's reading that is like, well, I don't get to go on vacation. Must be nice. I don't want to see anything like that in records. I'm not, again, I'm not suggesting you can't do it, but I don't want to see it because they latch onto that stuff. And, you've got to talk about the bad stuff. The Dells. Thank you. The Wisconsin Dells. Yes, we went up there one time and I was like, this is like the Lake of the Ozarks, just colder. And it poured on us, so it was cold. But thank you. But yeah, you've got to make sure. It makes it hard when you're not following normal, medical guidelines for treatment of a disease. I had this conversation with somebody yesterday regarding folks who are homeless or overtly psychotic with delusions, and so they don't take their medication. And I'm like, the problem is they don't want to go to the doctor. There's no documentation. It's really tough to document what's wrong when they're not going. Unless you have some of those and it depends on the Lyme's. So if you have like ankylosing spondylitis with it, you have, I don't even know what medically gaslit means, but somebody asked, what if you're medically gaslit? I don't.
Yeah, that's me. So basically, I've had a situation with my primary care physician where I've complained to him about my issues. He's told me it's all in your head, and then proceeded to put mood disorder on my chart without me even knowing about it. And then, of course, I went back in later.
Saw it.
And yeah, I mean, it's been a miserable experience dealing with my primary care physician. And now I'm finally connected with a Lyme literate doctor who I've been seeing for almost a year, and we've figured all this out. And prior to that, I had a lot of issues that were related to a car accident that I didn't necessarily share with my primary care physician because I was seeing all these other surgeons and other therapists and stuff, and I didn't, concern him with that. I mean, should I go back and revisit this primary care physician and go over everything and just dump it out on him?
Not if you've kind of moved on from that guy. I mean, sometimes the answer is you need to find a doctor that suits you better. I mean, it applies across every aspect of medicine. If you don't get along with the doctor's not apt to believe you, then kind of what's the point of seeing them?
Well, and keep in mind, like this primary care physician I had been seeing for 20 years, and I thought I had a good relationship with him until I started to let him know about these other issues that I was seeing other doctors for. And then, now I've actually got a diagnosis of Lyme disease and multiple co-infections from another doctor. So my medical records are going to be kind of compromised because, he again, I had gone back to him for problems that at the time I didn't know were related to Lyme. Now I'm learning they're 100% from Lyme disease.
Right.
And so do I revisit him just to get that medical record cleaned up, or do you think
it doesn't really clean it up? I mean, those records still say what they said at the time. I mean, going back in and paying a copay to go see this guy to say a big fat "I told you so" is not going to make much difference in his records. So I would just continue on with the doctor that now is, listening to you and treating your symptoms.
Right, and that's who I've continued with, and actually he's given me. I actually just met with him today, and he's given me some other um, primary care physicians that I could potentially go see that are familiar with Lyme disease and understand it.
Yep. And that's, well, and Britt makes a good point here. You know, there's a lot of folks that just don't understand it. The thing with primary care doctors is very much so, they deal with just like normal daily stuff. And this is an ongoing chronic illness that you really are better off. I mean, this group is a great resource for doctors who are sensitive to those issues and understand them. But yeah, I wouldn't say going back to that doctor is going to make any difference in your overall record. The current doctor is saying, you know, that you have these problems and that's better off.
But then my next question is, so when, like right now, I'm actually working with an attorney to apply for SSDI, and so when they go to pull all my medical records, you know, all this stuff's going to show up from this old primary care physician that's been out to lunch with me, you know, in terms of not recording things in the notes. And, you know, I went back and looked through all these records, and I'm like, this guy he's just lazy. You know,
Yeah.
he'd meet with you for 10 minutes, try to get you out his door. Hey, here's a script. Try this, you know, and get out of my hair. And, you know, I guess, yeah, I mean, that's probably going to hurt me. Right.
It will.
Yeah. So
The new records, so it really depends on how old those are. When you apply for disability, I mean, there are some exceptions to this, but basically you can't qualify for disability. Like for an SSI benefit, the first month you can qualify for a benefit is the first full month after filing. So if I got hit by a bus today and applied for disability today, the first month I could get SSI would be March. Okay. And it gets complicated with the dates, but you can get up to a year's of back due benefits. If I got hit by a bus 17 months ago and applied for disability today, I could get paid for a year back. So if those records are more than like 24 months old, their Social Security is really not going to look at them much because they're not as relevant to how you are today for the period that they're looking at. The same thing goes, you know, with any other area, because people will say, you know, I'll get a 56-year-old whose back hurts and they're like, oh, well, I was in a dirt bike accident at 16. You need those records. I'm like, I don't need those records. You worked up until 17 months ago. I can tell you that the records from 16 to 17 months ago aren't going to show me you're disabled because you worked that period of time. Because if you're working over, you know, making over 1620, you're not disabled by definition. So I don't need records that go back that long. Social Security is not going to look at them. It's not relevant like when you hurt yourself. What's relevant is how it's hurt you recently and what those limitations are. So I'll move on. So we'll just keep moving forward here. Again, if anybody has any questions, let me know. But Social Security, when they look at your onset, and this partly goes on if you're working while you're applying, if you're making over 1620 when they make a decision, you lose. Because it's such a long wait, if you have periods of time where you try to work and it fails, if it's over, again, it says 1550 because that's a 2024 number. If it's over 1620 a month, and lasts less than 6 months, it can be considered an unsuccessful work attempt. So like I said, I won't tell people they can't work during this process. If they say they've got an opportunity to try to work full time, they can do that. If it lasts less than 6 months, it doesn't count. If it lasts more than 6 months, then their new onset of disability is the day they stop working again. Because Social Security considers the 6 months a successful period of time. But again, I will never tell anybody they can't work. I will, like I said, I'll explain to them what happens if they work too much for too long. And we can also, because we talked about onset dates, like when somebody can be found disabled, because Social Security can pay you up to a year prior to your filing date. If there's a period of time in there where somebody worked 2 or 3 months, then that's considered an unsuccessful work attempt, and it doesn't count against them. Oh man, somebody's asking me a paragraph 1 question with the CDC in it, so I'm going to say I don't know. CDC guidelines. It's not necessarily the diagnosis, it's the symptoms and what your doctor says. I've never had a judge come out and say that a doctor's diagnosis didn't meet the CDC guidelines. So they will look, when they look, it's very symptom based. So you've got to talk about the severity of the symptoms. When it pulls over into kind of the inflammatory arthritis piece of it, they start looking at blood markers and inflammation. But then again, arthritis is one of those things where sometimes it meets the requirements and sometimes it doesn't. It's all based on that spectrum of symptoms. So that what the big part of that is frequent treatment. Like I always tell folks to try to see a doctor once or twice a month. More is better as long as it's good. So this is kind of a general analysis. Social Security is obviously a governmental agency, so everything's very regimented and procedural. So the first thing Social Security looks at is whether or not you're making SGA 1620. If the answer is yes, you get denied. If it's no, they move on to whether or not you have a severe impairment. By and large, only one time have I seen Social Security say somebody didn't have a severe impairment, and it was because they didn't get their medical records on an initial application. But a severe impairment is anything that has more than a minimal effect on you. It does. Having a severe impairment doesn't mean you can't work. It means you have a condition that requires treatment and has some limitation on you. I mean, if you have a bad back and you can't lift 100 pounds, but you can lift 50, there's still lots of work you can do, even though you have what Social Security would call a severe limitation. But once you get past that, Social Security starts looking at what they call listings of impairments. There's no listing for Lyme disease. It is based on kind of that constellation of symptoms. But once they get past the listing piece of it, they assess what is called a residual functional capacity, which is kind of after you take all the limitations, what are you left with? And they'll look at your past work. And if you can't do your past work, then they may look on to other work. But that first step is whether or not you're making, again, it's 1620 because that's last year's figure. The second step, severe impairment, is really not an issue because if you've gotten this far, you've got medical records that show you have a problem. And then they start looking at listings. I have examples of listings, and this does kind of trail over into the rheumatological listings because they looked at elevated, blood markers. Then they look at like swelling and arrhythmia, like swollen red joints. This one happens to be, I'll see if I can make it bigger. It's hard to see. You don't need to see all this really. This is just an example. And I use this as an example because some things are subjective, some things are objective. This is the listing 1204. All of the psychiatric listings are in the 12s. The rheumatological are in 14 in the immune system. But this is just by way of example here. This is for depression and bipolar. And so all of these things in here are based on report: depressed mood, diminished interest in activities, appetite disturbance. Slip over and look at the manic piece of it. You've got pressured speech, flight of ideas, distractibility. All of those things are listed, are based on report. And so the more times you report them, the more times Social Security sees it, the better off you are. For the psychiatric listings, all of them also require what they call the B criteria, where they look at ability to understand, remember, and apply information, interact, concentrate, persist, or adapt, which really has to do with like stress management. But again, these are all based on report. So if you're not telling anybody, nobody knows, it doesn't show up in the records, and there's no way for Social Security to make a decision based on what they don't see in medical records. So that's the subjective complaint, and I use that just to compare with objective findings from an echo, where they would look at how much your heart pumps. So this is the listing for congestive heart failure. It requires an ejection fraction of 30% or less. And some of the other things, which is the fatigue, shortness of breath, chest pain. But that is an objective test that is done. Social Security requires like in back pain issues to meet the listing. 1.02, you have to show that you have nerve impingement. Now, if you don't meet the listing, that doesn't mean you lose. It just means you don't meet the listing and they have to move on to the next step. Because by way of example, if you have somebody with an ejection fraction of 35, so that's the percent your heart pumps. Normal is between 55 and 65, which doesn't make any sense to me because you would think it would be 100 would be normal. But 55 to 65 is normal. So 30% is about half a normal. Now, if you have an ejection fraction of 35, that doesn't mean you lose. It just means that they have to move on to the next step, where they look at your RFC, or residual functional capacity. So that's where they look at what you are left with. So in a hearing, Social Security, the judge will present to a vocational expert what they call a hypothetical question. And they'll say, assume a person of the same age, education, and vocational history as the claimant who has the following limitations. And they'll go through and talk about how long somebody can sit, stand, walk, lift, push, pull, carry, all of those sorts of things. And then they'll look at interacting with each other, whether or not they need to lay down during the day, how often they'd miss work. And they will pull those sorts of limitations out of what they see in the records. If someone is under 50, the standard for disability, if you're under 50, is any job in the national economy. So if you are a 49-year-old construction worker, Social Security looks at whether or not you can do sedentary work. If you are a 51 or a 50-year-old construction worker, they start looking at whether or not you can do light work or heavier. So if you're limited to sedentary work at 49, Social Security will say that you're able to work. If all your past work is light or heavier, and you're limited to sedentary work at 50, then you win. There's another line in the sand at 55, another one at 60. Social Security has what they call grids, or medical vocational guidelines, where they match up your past work, the skill level of that work, the exertional level of that work, and then they look at what limitations you have. So if you move on to the 4th step there, and you're not able to do your past work, and you're under 50, then they move on to step 5, which is where they apply it to any sort of work in the national economy. So it definitely gets easier. The older you get, the easier it is to win. And really, the more you've been able to work, because judges are people. If you're 55 years old and they look at your earnings record and it's full of zeros, then they don't know why you weren't working before you applied. And so they assume that you're not that motivated. We have one judge that calls that a very minimal, just a minimal work record, or a modest. She says a modest. You have a modest work record. That's her nice way of saying there's no earnings in here. But if you're trucking along making $50,000 every year and that stops, then Social Security assumes there's a good reason for that. So it does make a difference when they evaluate the claim as to whether or not they show years of earnings. And we do always look for, in every case, we ask for a physician's opinion, a doctor's opinion on that RFC. We have a form we send out that addresses sit, stand, walk, lift, push, pull, carry, handle, finger, feel. On the psychiatric side, it's the concentrate, focus, stay on task, remember things, get along, handle stress. Typically from, looking for that opinion from a doctor who specializes in that area. If it's a mental health issue, you're looking for a psychiatrist to say it. If it's a back issue, a pain management or an orthopedist to say it. The more specialized and the more kind of on point, the better. But they do make a difference. So lots and lots of treatment, lots of talking about the problems. That really is the key. Like I said, always talk about the worst 3 days, how you feel on those days, what those days look like, where the pain is, what brings it on, what you have to do to relieve it. Talk about how it limits functioning throughout the day. Can't be up that long before you're exhausted. Again, it really just kind of depends on the person and the severity of the symptoms. So, does anybody have any questions?
At this time, I'm wondering if we want to go ahead and turn the recording off. And then if there are more questions, would that be okay, Britt and Kurt? Okay, let's go ahead and stop the recording.